Open this meeting at 1 o'clock, Tuesday, May 14th, 2024. We're here to discuss a vacation abandonment. I think we need to go into the public hearing mode so we can hear the rest of this. So I'd entertain a motion to go into a public hearing.
So moved.
A second.
Okay, let's make that a roll call.
Commissioner Cassidy?
Here.
Commissioner Dozier?
Yes.
Commissioner Zimmerman?
Here.
All right. We're in a public hearing, so let me just review the procedures. We're going to hear from the staff report, and then we will have opportunity for testimony. Do we have anybody signed up for that?
Yes.
Okay. We have testimony, so we'll have our supporters, neutrals, and opponents for 5 minutes, and then chance for rebuttal. We'll close. Reminder of the Shoshone County rules for public hearings. If you want to speak publicly, you need to sign the signature sheet. Please don't speak until you've been recognized. All public hearing proceedings shall be recorded electronically. Please don't interrupt the speaker. If you have evidence, please submit with 4 copies. And let's see, I think the rest is pretty obvious. Everybody else will be respectful of the speaker and their time. And then once the hearing closes, there will be no further evidence or testimony presented. Okay? All right. Staff report. Why don't you start us off, Mr. Martinson?
Thank you. Dan Martinson for the record. This is an application by Keith Trout, a petition to vacate and abandon a portion of an unnamed right-of-way within Shoshone County. It is case number VAC-1000-23. On or about May of 2023, an application was submitted to County Building and Planning Department. Throughout the last year, we've gone through a variety of steps to get here. And so here we are, and as the planning department issued a notice of public hearing on this application and was published in the Shoshone News Press on April 12th, 24, April 26th and May 27th of 24. On April 12th of 24, notification of adjacent property owners within 300 feet of this project site was completed via regular United States Postal Service, and a legal notice of hearing was posted upon the site. A public meeting was scheduled for Shoshone County Board of Commissioners on May 14th, 24. Findings of fact in this case, the applicant is, and the petitioner is Keith Trout of 128 Grubich Road in Pinehurst, Idaho. The one up north, not the one down south. Property owners are Keith Trout and Afton Trout. The proposal is to vacate a portion of an unnamed right-of-way that was originally deeded to the county via instrument number 166391, recorded back in December 5th of 1955. It has been known to the county as parcel number 48 North 02E069835. And in your packet, there's a map representation, and we can identify that in a bit, or if you have questions, we certainly can. It identifies this strip of property that is in front of what we know as Cruzit's tracks 1 through 7, I think, or maybe 1 through 8. And so that's a portion of that tract is what is being requested to be vacated. The location is located on the west of Pinehurst, Idaho, and is addressed as 128 Grubich Road. It's known as the applicant's parcel is 48 North 02E069700. The zoning in the area is currently natural resource. The existing surrounding use are residential uses. The comprehensive plan designates the area as the West Shoshone Corridor. Historically, most of the development pressures are occurring in this area. Competition for residential and industrial and commercial land is very high in this district. The corridor has a long history of mixed land uses and higher densities. The comprehensive plan specifically promotes the continuation of mixed uses, however, warns of density and impact to adjacent uses. In our findings of fact within Idaho Code, we list out a few of these things that are findings of fact. Portion of the public right-of-way the applicant is requesting to be abandoned and vacated is not improved for public or private use. The portion of the subject right-of-way is not necessary or required to provide access to property which is not owned by the applicant. No property is left without access to a public right-of-way or an abandonment. It is in the public interest to abandon and vacate the excess right-of-way and place the property into private ownership, which may be taxed so as long as the order reserves easements for existing public and private utilities. In this application, all of those things have been met. The area of city impact in this area, it is within the area of city impact of the city of Pinehurst. They were solicited for comment, and on September 14th of 23, Carla Ross with the city of Pinehurst, the council was unanimously in favor of the request to vacate this portion of right-of-way per their meeting on September 13th. Public Works Department for the county was solicited for comment. On September 14th of 23, Stephanie Featherstone with the Department of Public Works indicated that Shoshone County needs to keep a 40-foot right-of-way on Grubich Road, which is the main road in and out, not to be confused with this strip. On Grubich Road, Public Works did not foresee needing any additional right-of-way and would agree to vacate in front of parcel 48 North 02E 069700. Avista was solicited because of utilities. In an email dated September 30th, Luann Weingart of Avista indicated that they request an easement over the entire vacated portion for existing gas and electric distribution facilities. There is a deed being prepared for that as one of the conditions. Ziply Fiber was provided an opportunity to review information for this vacation. As of the writing of this report, we have not heard a response from them. What I can say to that too is any existing placement of utilities or existing easements will always stay in place with a vacation of right-of-way, and so they per Idaho code, it cannot be. This does not absolve that. So if there is an easement there, if there is infrastructure there, then it remains in place. As of the writing of this report, the Planning Department has received no public inquiries or written testimony. The next section 3 is the applicable legal standards that lists out the variety of county codes, including the subdivision code, the comprehensive plan, and various Idaho code sections that address not only these types of hearings and processes, but particularly the vacation of right-of-way processes. Section 4 is a recommendation by the planning administrator. It is a recommendation of the administrator based on the submitted application materials, any agency comments, and public testimony that we've received, not today. Pending testimony of the applicant as well as additional public testimony is a recommendation of the administrator to approve the application with the recommended conditions of approval. Based upon enough evidence that the general standards as stated with the above applicable standards have been adequately addressed. Section 5 is a draft set of conditions of approval that we put in most of in these cases, and we add in specific ones as needed. In a sense, the first one is that all other rules will stay in place, and they'll need to keep meeting the other rules and regulations. The next one is this application is approved based on what's in the application and nothing more. It also lists that the Board of Commissioners will cause to order or resolution to be recorded. And so these are, vacation would be a resolution, would be recorded in the county records and the official map of the highway system to be amended as affected by the abandonment and vacation. All existing easements of record shall be reserved and maintained for the continued use of existing sewer, gas, water, electric, or other similar utilities, pipelines, or appurtenances. The applicant shall file and record a lot consolidation deed incorporating the abandoned and vacated right-of-way into the adjacent lot so that only one lot exists. The remaining section is in case there's additional supplemental conditions that you wish to place, there's a section for that. Section 6 is a draft conclusions of law. Based on the code, these standard conclusions are required to be met. We've gone through it and drafted them as in the affirmative, so you'll need to read through those and formally make that a decision or opinion. And if there's any reason to not to, then we'll need an explanation why. And then I put in a draft recommended motion. When and if the time comes to make a motion on it, there's a draft there of a motion to make for this case. We received comments from, like as listed, from the Public Works and in the city of Pinehurst, and that's all in your packet. Maps were provided in your packet demonstrating the proposed area to be vacated along with the tracks. If there's any particular questions that I can answer as far as what's being proposed and what's not being proposed, how this works, I can answer that. And then the applicant is here for any other questions that may come.
Any questions from the board at this time?
Yes. In section 2, on 211, it talks about area of city impact, and it talks about that the city council unanimously in favor of the request to vacate a portion of the right of way. Did they vacate any of the, did they do a vacation of this right of way? Was any of this right of way?
They were in favor of this request. No,
was
this
it.
is
So
not
they
their
don't have
jurisdiction at all, so
Okay. Okay.
there's no jurisdiction on their part.
Okay.
They were in favor of this petition.
You're in favor of us giving our land away.
Yeah. Okay.
Okay, any further questions? Okay, does the applicant want to speak?
Keith, is there anything else you wanted to add on that I didn't cover?
I couldn't say it any better than you did.
If there's any particular questions, then certainly one or all of us can answer.
Okay. At this point then, I guess we'd be ready for testimony by supporters. Did you?
I think all we had for testimony was the applicant.
The applicant.
So,
Oh, that's all we have as staff? Okay.
It's marked no.
There's no testimony there, so we've got that. Okay. Then, so we have nothing by supporters, we have nothing by neutrals.
I screwed up. I wanted to stop.
Okay.
I'm sorry.
You just marked no on the testimony part,
I'm
but
sorry.
I
I
understand.
messed up.
Are you a neutral?
Neutral, yeah.
Go ahead. 5 minutes.
Dan, don't take this wrong, but here in the official highway map of road map of Shoshone County, there is none. We all know that. That was supposed to be done 20 years ago. There's been no public hearings. Just so you know that going through the minutes of the meetings me and Joe Avery have, we found that Northern Pacific actually owns some of these roads. What the deal is of the county can use them and Northern doesn't pay any money to. So unless this, I mean, I heard you said it was deeded to you. I don't know from who or anything else. But this is so messed up. The roads are the Potlatch Road. I believe you guys, not you guys, but the last commissioners actually gave federal land away because that was federal given to the railroad. I think the old commissioners actually did screwed up big time on that. The process needs to be done where these are actually dedicated or roads that we know are roads. It takes a lot of work to do, but it needs to be done because who knows what roads you guys are giving away, who owns them. So that, what? Oh, and also I believe in code it actually says that you can charge for these giveaways too. And I don't think financially right now you guys are sitting in a position just to give land away. Thank you.
Okay, thank you. And we have no testimony by opponents. We do have opportunity for rebuttal. Do we have anything, Dan, from your department?
I was going to respond to the one part about looking for the deed where we got it from this 166391. In the deed where we received this as a part of Cruise's tracks. It was granted to the county. I'd like to read it. I'm trying to. So deed number 166391, recorded December 5th of 1955. I'll paraphrase for a minute until I can find it. It was deeded from somebody named Kruzitz, which the original plat there. Still not the right number. Deeded it to the county, dedicated for roads purposes, roads and access purposes. Later, Pine Creek Road turned into Grubich Road after the bridge went away. And so the main road of access is Grubich Road. This section here was still deeded to the county via that individual. So we own it, fee simple, and we're vacating it because we determined that to be the jurisdiction in this particular case. So somewhere in here is that deed. All the other properties either already have access across that area and or they access Langford. Anyway, that was the gist of the we own it and we have jurisdiction to vacate it is in that deed.
Okay.
Okay. All right. Any further comments on rebuttal?
None for me.
Okay. Give the opportunity. Anything else you'd like to say?
I have a copy of the deed, and that was, in my opinion, a legal notice that it was given to the county, so,
Okay.
I finally found it. If you want
Okay,
to.
go ahead.
This indenture made to enter this 5th day of November 1955 by and between Philip Kruzich and Naomi Kruzich, his wife of Julietta, Idaho, parties of the first part, and Shoshone County, a municipal corporation, party to the second part, witness that for the consideration of the sum of $1 to them to hand paid, the parties of the first part do hereby give, grant, and convey to said second part in the trust for the owners for the adjoining parcels of the land for following described real property for use as a road and street, said property being situated in the southwest one quarter of the southeast one quarter of section 6, township 48, 2 east in Shoshone County, Idaho. And it goes on to further describe the actual box of the meets and bounds description of the box.
All right. Okay. Any further questions from the BOCC?
I don't have any.
I had a question that I underlined. It's more of a legal question. If we can, should we do this afterwards?
Depends on what the question is.
The question is on Idaho Code 4203, and it would be I, because it does talk about the fair market value of the property. It says if commissioners determine that the highway or public right-of-way parcels to be abandoned and vacated in accordance with the provisions of this section has a fair market value of $2,500 or more, a charge may be imposed upon the acquiring entity not to exceed the fair market value of the parcel as a condition of the abandonment and vacation. I know we can't do it with federal properties, but that was just one of the questions. I wanted to make sure that if we're able to do that, or if that's...
The BOCC would like to pursue or vet out whether or not a charge can be imposed on the requester or recipient of the vacated property. I would suggest the BOCC not make a decision today, to table the public hearing until a later date and to seek out a formal legal opinion regarding the appropriateness of that statute in this context.
Okay.
Let me ask for clarification. Will we table the public hearing or just table the decision afterwards?
You can do either. If you feel comfortable that you've received all the input you need for purposes of the public hearing, you can close the public hearing and make a decision at a later date. If you wish to keep the public hearing open for additional comment, then obviously you would continue the hearing itself.
Okay. Is there any further questions or comments from the commission before I would close the public hearing part of this?
No.
Okay. Then I will motion or entertain a motion to close the public hearing, go back into regular session.
So moved.
Second?
All in favor?
Aye.
Aye. Oh, we did a roll call. I'm sorry.
Commissioner Cassidy?
Here.
Commissioner Jones?
Yes?
Commissioner Zimmerman?
Here.
All right, so we're back in regular session, Commissioner deliberation, so no further evidence at this time. Commissioners, thoughts, concerns?
No, I would just kind of, I was going through the code as we were talking, and I just wanted to make sure that it talks about fair market value of the property and whether we should be looking into that or not.
I think it's a good point. It seems like we should probably go through it and make a decision so that we're informing future folks before they make application for right of way.
I would agree with that. One of the issues we had in the property over on the river has to do with federal property, and the code does specifically state about federal land right of way that was given to a public entity. But this isn't that. This is
right.
This is property that was deeded or was given by another landowner for public use for a tract, and then now that landowner, it does state where if it was still in that landowner's name, we couldn't do anything, we couldn't charge it. But this, I'm just concerned that we make sure that we cross that, dot our I's and cross our T's on this.
So what action would you want to take?
I would like to not continue the hearing, but give a final decision, wait to give a final decision, put it on a date, and then we can go ahead and talk with legal to see if that part of the code would apply.
Okay, so you would table our decision,
Yes, right.
is what you were thinking about. What are you thinking, Commissioner?
I don't have a problem tabling it to investigate, to see about the code and how it applies for future applications.
Yeah.
Okay. In that case, I would entertain a motion.
Okay, I'll motion to table the decision for further review of the Idaho code that we're looking at, and to get with legal and get an opinion on it before the decision we make.
Before we make a decision.
Mm-hmm.
So do we need to set a time?
Could I offer that we set a date certain
Mm-hmm.
time?
Mm-hmm. Mr. Prosecutor, do you think if we set this out 2 weeks, 3 weeks, that would be adequate to?
Oh yeah, you can set it tomorrow. I've already done the research, so I'm prepared.
Okay. Okay.
Just in case you might see if we can get that explanation now.
Is that something that you could share with us now?
Or would it be better than
Or I've
Not
got
in
them
this forum.
in this form. Okay. All right. So we have a motion to table. Would you be willing to amend your motion to 1 week?
Yep. Oh, we can do it. Table it for a week.
Table for 1 week. Okay.
Okay, I'll second.
Seconded. Okay. So motion to table for a week while we get that information. Then we'll come back together and make a decision with that information in place.
Okay.
Okay. All in favor?
Aye.
Aye.
All right. Motion to table for 1 week while we gather a little further information. And so that would be a week from today. So that would put us on next Wednesday. Okay. All right. And with that, I think, is there anything further you can think of?
Not this time.
Okay. With that, I think we are adjourned.